They say they can. And they act like they can, and on many occasions they do. Most of the time when they do that, the person being arrested doesn't know they can't do it. And so they just comply willingly and will make a fuss and everything. Well, I'm not that way. Sheriffs, constables, and other officers of the executive branch of government had always been recognized as having authority to arrest for felonies committed for misdemeanors running from breach of peace. But this is the extent of the power of arrest without warrant. And this constitutional principle is well grounded in each common law safeguards of individual liberty. In England, this is a case now I'm reading from, this is a case quote. In England, under the common law, sheriffs, justices of the peace, coroners, constables, and watchmen were entrusted with special powers as conservators of the peace, with authority to arrest felons and persons reasonably suspected of being felons. And many times you'll find that even though they were reasonably suspected, they weren't. And so they got dismissed. Conservators of the peace also had the authority to make arrests without warrants in case of a misdemeanor which involved a breach of the peace committed in the presence of the officer making the arrest. It has nothing to do with me. I'm just reporting to you what the courts are saying, what the common law has said. So don't take it from me. This isn't coming from me. This is fact you can look up. These are cases on the law books, on the reporters of the law books. But the law books support that. You can't do this stuff. In a legal article entitled "Arrest with and Without Warrant," written in the University of Pennsylvania Law Review, Volume 75, Number 6, April 1927, page 45, numerous authorities were cited in support of the following proposition. Quote, "It is usually said that not even a peace officer is privileged to make an arrest without a warrant for a misdemeanor which does not amount to a breach of the peace, and there are many cases which expressly deny the privilege to arrest for such a misdemeanor." In the annotation of the American Law Reports, Volume 1, page 585, is found a legal study titled "Constitutionality of Statute or Ordinance Authorizing an Arrest Without a Warrant," in which the following is stated. Quote, "It has been stated that in cases less than a felony, an arrest could only be made without warrant where there was a breach of the peace in the presence of the person arresting. The limits to the power of arrest by a constable without process was well defined in common law. To prevent the escape of a felon, he had authority to arrest anyone whom he reasonably suspected to have been engaged in the preparation of a felony. To prevent breaches of the peace, he had the right to arrest any person who was engaged in, or in his presence threatened to engage in a fray or other breach of the peace. Beyond this, the law did not allow him to exercise the function of determining whether there was a sufficient case of the violation of a law to justify an arrest." The police officer doesn't have the authority to determine whether that case is justifiably getting to be arrested for without due process of law. In Tiefman Treatise on the Limitations of Police Power, Section 33 is found the requirements for a lawful arrest and the exceptions to a warrantless arrest. 33. What constitutes a lawful arrest? As a general proposition, no one can make a lawful arrest for a crime except an officer who has a warrant issued by a court or a magistrate having the competent authority. Arrest without a warrant. Although it is the general rule of law that there can be no arrest without a warrant of the nature just described, yet there are cases in which the requirement of a warrant would so obstruct the effectual enforcement of the laws that the ends of justice would be defeated. For public reasons, therefore, in a few cases, the personal security of the citizen is subjected to the further liability of being arrested by a police officer or private individual without warrant. but the right thus to arrest without a warrant must be confined to the cases of strict public necessity. The cases are few in number and may be stated as follows. When a felony is being committed, an arrest may be made without warrant to prevent any further violation of the law. When the felony has been committed and the officer or private individual is justified, but the facts within his knowledge and believing that the person arrested has, by the facts within his knowledge and believing that the person arrested has committed the crime. All breaches of the peace, assaults and batteries, affrays, riots, etc., for the purpose of restoring order immediately. Assaults are there. The rule of the common law that a peace officer or a private citizen may arrest a felon without a warrant or on view of a breach of the peace has never been extended to any and all misdemeanors. While there have been some erroneous decisions that have recognized statutes authorizing arrest for misdemeanors that do not constitute a breach of the peace, none are based upon the meaning of due process of law. Thus, arrests are not lawful when only a misdemeanor occurs unless it is of the nature of a breach of peace. Common law and American jurisprudence, a peace officer cannot arrest without a warrant for a misdemeanor, although committed in his presence, unless a breach of peace is involved. And it goes on. It goes on. I wanted to get some to the event for vagrancy. The officer was found guilty by a jury of false imprisonment. The Supreme Court of Illinois upheld the conviction of the policeman and declared the rule of law regarding arrests without warrants. Blackstone says the constable has great original and inherent authority with regard to arrests. He may, without a warrant, arrest anyone for a breach of the peace committed in his view and carry him before a justice of peace. And in case of a felony actually committed or a dangerous wounding whereby a felony is likely to ensue, he may, upon probable suspicion, arrest the felon, and for that purpose is authorized, as upon a justice's warrant, break open doors and even to kill the felon if he cannot otherwise be taken. For Blackstone's commentary 292. In all other cases, however, the authorities are uniform. The constable or policeman has no authority to make an arrest without a warrant. Shanley versus Wells, 7 Illinois, 78. That's an 1873 case. In a case for false imprisonment, the Supreme Court of Maine examined the law regarding arrests and held the principles which, by the common law, regulate the right to arrest or cause arrest without warrant have been long settled both in this country and in England.